Objective, brought to you by the Ayn Rand Center UK, where we apply the philosophy of objectivism to everything. And today, the discussion is an interesting one to me. I hope you'll find it interesting. I think it's very relevant today since we're hearing talks about a national divorce. And for the first time in a long time, the left is talking about it, not just the right, not just fringy libertarians who have a particular theory of government, but the left. Sarah Silverman is one glaring popular example of somebody who's saying, look, we just can't agree anymore on ideology. We might as well get a divorce. Now, of course, this happened before in the 1860s, and it was preceded by an entire theory of states' rights and an orientation towards the Constitution, which still is alive today. So the question is, with respect to this divorce, are we in a compact, or was the Constitution a grant by the whole people to the government of certain powers? And how you answer this question determines a lot. To really help me get through this crazy maze of legality and philosophy, I've got my good friend James Valliant. James, help me with this, because I'm a little confused, and I know that the life of our union depends on how we answer this question. Now, it seems to me that the Articles of Confederation, which govern the quote-unquote United States right after the Revolutionary War, up until the ratification of the Constitution of the United States, that seemed like it was an actual compact between states. It didn't result in very good government to me. This seems different. What say you?
That is absolutely correct. The initial way in which the states were organized into a federal union, a loose federal union, can hardly be called really a government in one sense. We had 13 sovereign governments, 13 sovereign nations, and they met just to discuss the relations with Great Britain before the Declaration of Independence came out in something called the First Continental Congress. And each state sent delegates to Philadelphia to be part of the Continental Congress. And then there was a second Continental Congress, and it was only there that they decided to declare independence from Great Britain. And it was required, mind you, that it be unanimous before that declaration get adopted. It required unanimity between all of these 13 independent countries, as it were. Now, they proposed later on a way of organizing themselves, which was really a treaty between nations called the Articles of Confederation. It required unanimity for any changes to be made, and it required a supermajority for anything whatever to be done. So with either 9 or 13 states required to agree on everything, with each state getting one vote, and really no executive authority, it was clear that the Articles of Confederation, as you describe it, was a compact. It was really just a treaty alliance, like more akin, say, to the EU than to, but even the EU had more powers than the Articles of Confederation, frankly. More direct power exists under the EU than the Articles of Confederation gave the federal government initially. This was perceived as causing all kinds of problems. As we indicated in an earlier podcast, there were trade wars, tariffs being erected, trade wars going on between the states, all kinds of conflicts and confusion going on. And nor was the United States able to present a united front in a foreign policy way. And that was becoming increasingly urgent as Europe was going into the French Revolution and the Napoleonic era. So it was becoming increasingly urgent that America speak with one voice. For all these reasons, the articles were thought to be deficient. And so it was, there's an argument as to whether or not the Constitutional Convention itself was legitimately called under the Articles of Confederation. But that really doesn't matter. Unanimously, the Congress under the Articles of Confederation unanimously approved sending the proposed Constitution that had been developed in Philadelphia in 1787, the summer of 1887. There was this convention, the Constitutional Convention, with George Washington at its head. Well, the Congress under the Articles of Confederation unanimously agreed to allow that Constitution to go to the states, but it wasn't going to be ratified by the state legislatures. It was going to be ratified by conventions uniquely called by the people of those states, or the legislatures of those states, to see if it would be ratified. It required the same kind of supermajority of 9 out of the 13 states in order just to be ratified. Eventually, all 13 states did ratify it. The last comer of that, Rhode Island, only ratified because they required a popular plebiscite of the people. I say all this because it's important to the distinction here. The Constitution of the United States is not merely a continuation of the government begun under the Articles of Confederation. It was a radical break. It begins with a preamble that says, "We, the people, establish this Constitution," and it was established unanimously by all 13 states by independent conventions outside of their legislatures. So the people of the United States adopted, we the people adopted this new government, which transcended, it seems to me, think of it this way, if the Articles of Confederation really were just a compact of states, by their unanimous adoption by popular conventions, or in Rhode Island's case, by popular vote, trumps anything that previously came before and created a wholly new legitimate basis for legitimacy for this government formed by we the people. And within the body of that Constitution were imposed certain limitations on state power, such as all states must have a Republican form of government. Based on that theory, it seems to me that what we have is a government now, a federal government now, that can rule on the legitimacy of what states do. And once the states had unanimously joined into that, they're now part of a single federal government, not a mere loose confederation which they can drop out of anytime they want. Now, this was controversial. Madison said equivocal things about it, and Thomas Jefferson was totally unequivocal. He was an advocate of the compact theory. If the states do something that violates the federal Constitution, stamps on their powers, the states can reject it, said Jefferson. Well, his theory, of whether you like it or not, his theory was rejected, and rejected by the first Supreme Court, John Jay. I think the case is Chisholm versus Georgia, in which a citizen of one state sued in federal court the state of Georgia. And the federal court and the Supreme Court, under our first Chief Justice, said, yeah, you can do that. The federal courts have jurisdiction over a case that involves the whole state of Georgia versus someone who comes from another state. This inspired the 11th Amendment to the Constitution, limiting the federal government's power to federal courts' power to do just that. But until that constitutional amendment happened, the first case of any real significance from the Supreme Court was this Chisholm versus Georgia. It was done before Marbury versus Madison, so we're not quite sure. They hadn't established the Supreme Court's power to do this kind of judicial review, but nonetheless, it was asserted, and the states submitted to it, and they required a whole new constitutional amendment to fix it. So I think that the legal argument against the compact theory is a strong one. Nonetheless, the supporters of slavery and states' rights before the Civil War aggressively used this argument, and some of the greatest arguments against it were made by senators fighting slavery, men like Daniel Webster, who very eloquently argued again and again that unlike the previous Articles of Confederation, which were a loose confederation of sovereign states, we the people had established a whole new kind of government with federal supremacy.
Yeah, and it's unfortunate to me that the libertarian movement, particularly the anarchists, point to John C. Calhoun as their primary intellectual, a racist apologist, slavery apologist. I haven't read any of his stuff, so I can't speak with any actual firsthand knowledge of his arguments for the states' rights compact theory of government, because his slavery apology just makes me think that everything essentially comes from that moral premise. But the libertarians won't let go of this idea that it's a compact. So, and they do point to something that's true. The federal government has far overextended its powers over the states, which were to make sure that each state has a Republican form of government. And for the most part, powers were in the state's hands, not in the federal government's hands. It had very strict enumerated powers. under the compact theory of government, whenever the people of a state disagree with the reach and nature of those powers, they can leave the union. But we're talking about a perpetual union. So in the event that the federal government becomes too strong as it has today, what can we do with this grant theory of government? Now, the grant theory of government, I think is a very interesting one too. I want to throw this by you because the founders believed in sort of the fiduciary nature of the governors, that they had a fiduciary responsibility to their to the people whom they govern. Can you explain that a little bit in terms that I think the common man can understand? Because it's a very important distinction.
Well, each state, let's back up again for a little more historical context. Before there was an agreed upon Articles of Confederation, each of these sovereign states, these sovereign countries that came into the Articles of Confederation, had their own constitutions. Constitutions were things that existed. And bear in mind, too, that the Bill of Rights, when we had this new thing that we're calling no longer a compact, a federal union established by this Constitution, it still limits the powers of government and limits it enormously, giving it in fact, the drafters of the Constitution stressed the limited nature of the powers. They listed them, delimited them, and then they had the 9th and 10th Amendments just to stress that we mean just these specifically limited powers. So the way to fight it, my friends, my first comment on what you first said, the way to fight it, my libertarian friends, is through the federal courts. The federal courts are what is going to protect us against encroachments of state power, which can be just as pernicious, just as evil as federal power. In fact, sometimes more intimately so as violations of our power. Drug laws and the public education system, criminal law are all basically Abortion laws are now back in the States, thanks to the Supreme Court punting it back there. So we have just as much. And in the case of slavery, if that is your justification for secession, but all by itself, I oppose you on principle for seceding for that motive. It is an illegal, illegitimate, immoral motivation to secede on that basis. Now, the federal government has gotten all out of control. There's no question the federal government has gone crazy out of control. But once again, it is a misread of the original Constitution. It is the Supreme Court has ignored that. See, when we say the supremacy of the Constitution, we're not saying that the Constitution gives them all the powers in the world. When I say supremacy of the Constitution, I mean with all the words, with all the limitations, with all the strictures, as well as a broad reading of all the rights that come with it. Now, the governor's power. Governors, in fact, states in general, states have a specific, and the 10th Amendment makes this absolutely and perfectly clear, the states have their own jurisdiction, a jurisdiction that the federal government can't step on. That is part of the Madison, and the Constitutional Convention itself says that we are a system not only of separation of powers at the federal level, judiciary over here, legislative over here, executive over here, we're also a system of separated powers. Federal government does certain things, the state government does other things. And it was written in such a way that it's the residual powers. So from the federal government standpoint, the governors have this residual power that's undefined by the federal Constitution. On the other hand, it has to follow the limits of both Section 4 of the body, and now, thanks to the 14th Amendment, at least done in a certain way, the Bill of Rights is now enforced against the states, if that makes sense.
Thank God.
For the Bill of Rights to be enforced against the states, though, we have to reject this notion that the states can opt out and have slavery or censorship or established religion or whatever other kind of tyranny they want. You know, we have reached a point of politics that is so intense and so fiery that both sides sort of want to split up. That was the situation before the Civil War. It really, really was. Y'all want slavery, y'all want freedom. Why don't we just do two different nations? Well, that's what the Civil War was all about. You don't get to have two nations, especially if what you want to do is get away with violating people's rights. And in my mind, as I said in our last podcast, the 14th Amendment put that to bed. It required states. No state shall deprive any person of equal protection. No state shall deprive any person of the privileges and immunities of the citizens of the United States, or deprive them of life, liberty, and property without the due process of law. This gave the federal courts jurisdiction over what the states did and a capacity to review the legitimacy of their legislation. In fact, their own constitutions. Their own constitutions are now subject to federal review under the 14th Amendment. The 14th Amendment put to bed any libertarian notion of states' rights, in my view. We had a whole civil war about that, and then amendments that were passed to make sure that crap like that never happened again. So I have to say, for good or evil, we are in a federal constitution. If it comes to a point where the federal government is violating our rights, then we take up arms and we rebel against it. But we're not at that point yet. And it seems to me that the federal government's imposition of the Bill of Rights through the course of the 20th century did more justice against the states, eliminating all of these take, for example, Jim Crow and segregation in the South. When finally the Supreme Court woke up and started to enforce the Equal Protection Clause of the 14th Amendment against the states, suddenly all of these racial injustices in law that states were doing were unconstitutional, and the civil rights, shoot the gun, the races were off with the civil rights movement. So yeah, a great thing happened to law enforcement, to the racist laws that were happening in states, things that were going on in public schools that violated the religious, the Establishment of Religion Clause, et cetera, et cetera. So I would remind our libertarian friends that there were all kinds of rights violations and injustices on the state level that this new jurisdiction of the federal courts have protected us against. Yes, we're dependent on them for things like, say, abortion. And if the Supreme Court, the top federal court, gets that wrong, it gets wrong all the way down the line.
So the courts are supposed to be a check on government power. They're supposed to be the means through which we can affect change for the better, or make our government more consistent in its application of the Constitution. What do we do when the courts are so corrupted by political ideology, as they have been for a very, very, very long time? Now, can you trace a little bit of the first sort of corruptions within the Supreme Court? I mean, there's been a series of bad decisions since the 19th century, but I mean, in particular.
Start with Dred Scott. A slave escapes to a free state, and guess what? He can be hauled back to the slave state, regardless of the free state's laws on slavery. This guy named Taney gave us Dred Scott, and folks like him unfortunately dominated the 19th century Supreme Court. When the 13th, 14th, and 15th Amendments were passed to the Constitution, the Supreme Court immediately gutted the meaning of those amendments. The 14th Amendment's Equal Protection Clause was meant to give equality under law. The specific motive were the free black slaves, but it said can't deny any person in their jurisdiction equal protection. Well, the Supreme Court wouldn't have any of that literal nonsense. And so in 1892, under Plessy versus Ferguson, the law could recognize differences between blacks and whites, segregate them in public facilities, have laws that said you have to have the separate facilities and separate, oh, wait a minute, separate but equal is okay under the Equal Protection Clause. In fact, any kind of recognition of a significance to race is okay under the Equal Protection Clause, or take the Privileges and Immunities Clause. Immediately gutted, meant to enforce the Bill of Rights against all the states to protect all persons within that state. The Supreme Court said that's not what the Privileges and Immunities Clause means at all. They tossed it out the window, forcing us to go through the Due Process Clause to enforce bit by bit the elements of the Bill of Rights against the state in a slow, piecemeal fashion. Now, while that was going on, the Supreme Court, at least in the late 19th century, began to recognize the limits of federal power when it came to regulating commerce. There is no general power to regulate commerce that was given by the Constitution to the federal government, and yet that began to be encroached on more and more and more. In the late 19th century, century, laws were struck down routinely as violating the Interstate Commerce Clause, which was no general grant of economic regulatory power to the federal government. That started eroding and going by the wayside in the 1920s, in the 1930s, and then especially by the 1940s with the Frankfurter Court appointed by FDR. It now became clear that the Interstate Commerce Clause meant just about Congress could regulate just about anything that had any impact whatever on commerce or the economy, or that the necessary and proper clause, for example, we can strike out that word necessary. Anything proper to do anything that vaguely regulates commerce is A-OK. And so for the last 80 years, we've been living under a regime where the Supreme Court has basically just given the nod. Now, in the 20th century, what's heartening a little bit is that we've had in the last 20 years or so several cases where the Supreme Court has actually invoked the Interstate Commerce Clause as limiting what the federal government can do. There was, for example, a law, the gun law, where they said that you couldn't have guns within a certain distance of schools. The Supreme Court knocked that down, saying, that does not come with the Interstate Commerce Clause. How does the federal government? They didn't even use the Second Amendment, my brother. They used simply the Interstate Commerce Clause to say, we don't see how the federal government under the Interstate Commerce Clause can regulate guns near schools. How is that really connected even to interstate commerce? So there's been a slow stepping away, I think, but a very slow and gradual one by more conservative courts in recent decades. But still, effectively, the Supreme Court has said that the Congress has unlimited economic power over the United States. Now, that's not within the Constitution, and a compact theory of getting out of the federal union isn't going to fix that. It really isn't. I can't imagine even a conservative union of states actually adopting a free market capitalist system. They'll have some kind of religious theocracy, as far as I'm concerned, something like Trump land. If you have Trump land in this country, what you're going to have is you're going to have, a mercantilist state that looks very much like, what a Labor Democrat would have wanted 30 years ago on one side, and a whole bunch of violations of civil rights based on religion on the other hand. That's what I predict conservative land. If I predict progressive land, I'm predicting a socialist state. So I do not like this idea at all of segregating out anymore. Well, it was bad for the Civil War. It's still bad. Perhaps the evil isn't as great, as chattel slavery, but we are dealing with evils that both sides want to protect, in effect, by this kind of new call for segregation or of the states, a separation, cessation is, I guess, the better word.
Yeah, the way you talked about the communities of the tradition state versus a socialist state reminds me of my reality check on anarchy. So you should check that out, since we are in a sense dealing with anarchy right now. That's what the compact theory of states would sort of lead us to, is that kind of thing. Now, all of this said, as terrible as Trump was in many ways, some people at the very, very top of 2016 said the only reason I'm voting for him is the possibility of replacing Supreme Court justices, which he in fact did. Now, some of those decisions have been leading us in the right direction. What do you say about his nominees and their job so far in the Supreme Court with respect to turning us back to the this ideal of our relationship to the Constitution?
In some ways, the conservatives are better, and in some ways, the liberals are better on the Supreme Court. If I were to rank them, I would say I would prefer to live in the conservative world, which is at least keeping some tenuous hold on the original Constitution. As tenuous as their own hold is, at least they state some nominal assertion of connection to it. The left would take us completely unhitch us, unmoor us from the language of the Constitution. They would create positive rights, welfare rights. You have a right to education at other people's expense. You have a right to healthcare at other people's expense. They would have no problemo tomorrow. In fact, the three Obama appointees who are currently constitute most of the left on the Supreme Court would obviously, from their appointments, have no respect for the limitations that were both the Federalists and the Anti-Federalists agreed that the federal government has specific limited powers, but there's no liberal who agrees with any side of the framers of the Constitution here, and they've completely unhitched from it. So in this sense, I would prefer conservatives. Even if, it's going to kill me to say this, something so fundamental as a right to a woman's abortion is so important a thing to me that it is, you're getting on the verge of things like slavery and draft, and where issues I think are so intensely important that it bothers me. But on the other hand, keep this system intact, because that was the system that gave us Roe, that gave us a system whereby we could protect individual rights against majorities. So at least the conservatives would retain the frame of our constitutional system, where we might one day have something better, a broader understanding, a more principled understanding of rights.
Well, folks, if you're interested in what inspired this conversation, there was a series of editorials by Robert G. Nadelson in the Epoch Times. He's talking about the history of the Constitution. He's also written a series of books on the Constitution, which I am about 3/4 of the way through the first volume. It's called The Original Constitution. I think James should be teaching a course on the Constitution because it's amazing. James, I have to start wrapping up here. We've got a couple super chats. Jonathan Honig for $5. Thank you, Jonathan. Robert Nasir. James fitting a full lecture on the division of powers and hierarchy of authorities under our federal constitutional system in 30 minutes. Yes, you summed everything up in a very economical amount of time. You did. Jonathan Honig gives us another 99 cents. Thank you, sir. So upcoming shows, 6 p.m. UK time, the reality show. Who do you trust more, your family or Trump? Okay, I'd be interested in knowing why this question. 7 p.m. UK time, the Fountainhead Book Club for Ayn Rand Central UK members. The session will also be live streamed to YT members. James will have a course on the Constitution. Oh, this is great. So you will be conducting a course on the Constitution.
You said it. This is not the first time you've said that. And so Razi is, we're planning a course on the history of the U.S. Constitution and individual rights. We're planning for October, at the end of October. So by fall, we should have this, but it will be only for top level subscribers of ARCUK. But you did it.
Okay.
Inspired us.
Yes, and now I can't wait.
Just one other ad. Tomorrow, I'm talking with Nicholas about Star Wars, plot theme and romantic realist analysis of the original Star Wars films with Nicholas. So you can't miss that.
Oh, that's awesome. I can't wait to see that. I can't wait to participate in every single class that you're going to have on the Constitution. Tonight, folks, I am going to be having a discussion with the real Spike Cohen on the Fight Club. Is anarchy the purest form of capitalism? This is going to be blood sport, folks. Hopefully I represent our perspective. Hopefully I represent our perspective well. Also, don't forget to watch your reality checks. Don't forget to like and subscribe here because this content is great. Just listen to James. He gave you a lecture on the Constitution in 30 minutes. You cannot be fooled by the political class anymore after listening to James for just a few minutes. So imagine what an entire course on the Constitution would bring you. You should take it, all of you out there who are members, subscribers to the Ayn Rand Central UK. Take it. This is gold. Anyway, we have to go. James, as always, it's been a pleasure. Folks out there, keep applying objectivism to life. And in the spirit of that, always remember to check your premises. Peace.